Good afternoon and welcome to this panel. My name is Pablo Rocha. I'm the legal advisor at the Mexican Mission to the United Nations, and I'm thrilled to be moderating a very exciting conversation in this year's ACL conference, which, as we all know, is happening under these new circumstances that are becoming our new normality and our new reality. So it's a pity that we're not able to be all together in the same room, but it's very fortunate that we can at least do this virtually. And today, which is also coinciding with the 75th birthday of the UN Charter, we will be talking about immunities of international organizations. And we have a great panel to do that. We have 5 speakers, and I'll mention them very quickly because I know time is of the essence, and I want to be able to spend most of the time that we have on the discussion rather than on the introductions. But we have Meke Okeke from the World Bank with us. We have Beatrice Lindstrom from Harvard Law School. We have Nancy Perkins from Arnold and Porter. We have Carla Firstman from the University of Essex and Kena Graciano from Earth Rights International joining us today. And we're going to try to use, to the best extent possible, the little time that we have to talk about the evolution and the progression that we're seeing today in international law in the field of immunities of international organizations. This is a very vibrant area of the law, but also one that is pretty much alive, and especially with recent cases. And in order to do that, we're going to focus on one particular case from the Supreme Court of the United States, which is Jam et al. Versus International Finance Corporation. When this panel was first conceived, and that is why you'll see that in the title of the panel in the program, it mentioned 1 year after Jam and International Finance Corp. The thing is that with the postponement of the conference and with time passing by, we now have further developments on this issue, which we will be able to incorporate to our panel and to talk about now. So the only practical thing that I would mention in terms of procedure is for all the participants out there who are watching us, feel free to start sending your questions with the Q&A function from the start. As soon as you have a question, let us know and we'll group them together. The idea and basically the way in which we're going to run this is we'll try to have a conversation about these issues rather than a more specific set out of questions to the panel. So we'll move from one topic to the next throughout this time with our 5 panelists. And then with the time that we have left, we'll go into the questions from the audience, and time permitting, we'll take as many as we can and also try to weave them into our conversation. So that is pretty much all the time I wanted to spend on my introduction. So let's just get started. As I was mentioning before, we have this judgment from February 2019 from the Supreme Court, which was then followed by another recent decision in February 14 of this year by the District Court of the District of Columbia, which tackles again the issues and the decision that was made by the Supreme Court in 2019. And basically, it's linked to the way in which immunities are understood and applied, and to the exceptions that can be found to the immunities of international organizations. So let me turn to you, Kena, first to start with our conversation, because we're lucky enough to have you, and you have actively been engaged with this case law. So who better to explain a little bit of Jam than you? So please, if you could kick off the conversation, sharing with us the impact of these decisions and what the current status is. The floor is yours, Kenya.
Great. Thank you so much, Pablo. And I want to thank ACL for inviting me to be on this panel. So I'm an attorney who works for Earth Rights International, and we represent the plaintiffs in the case Jam the IFC. So as requested, I'll kick off with an update of the current status of the case from the Supreme Court decision until now. I just wanted to note briefly that the plaintiffs in this case are communities in India who were harmed by a coal-fired power plant that was funded by the IFC, which is the private lending arm of the World Bank here. So what the Supreme Court held last year is that international organizations like the IFC were no longer absolutely immune from suit. Instead, the regime that applies is what's applied to foreign states. It's called the Foreign Sovereign Immunities Act, or FSIA. And under the FSIA, what applies is what's called restrictive immunity, meaning that sovereign defendants are immune from suits unless they meet one of the outlined exceptions in the FSIA. So after the Supreme Court decision, the case was sent back down to the district court, and we were essentially still at the beginning of the lawsuit. And so this past summer, IFC submitted its renewed motion to dismiss. This included several lines of argument, but mainly, even under the new regime imposed by the Supreme Court, they felt that they retained their immunity. So under the FSIA, there is an exception for the commercial activities of sovereigns. And we believe here that the IFC's lending in the United States at market rates to private businesses falls squarely within this exception. So the district court had to determine whether, under the FSIA, the suit was based upon commercial activity in the United States. And how the Supreme Court has instructed courts to apply this language is to determine what the suit is based on, what's called the gravamen of a suit, and whether that is a commercial activity with the requisite jurisdictional nexus to the United States. So what the IFC argued is that the court should determine the gravamen by looking at what's the last act in the causal chain here, what actually injured the plaintiffs. And they argued this was the actions of the power plant in India. Therefore, the gravamen of this case was in India. We argued that what the court should look at is IFC's actions in approving the loan and failing to prevent and mitigate harms to the plaintiffs, and that was carried out from their headquarters in Washington, D.C. So in the February decision of this year, Judge Bates from the district court dismissed our case, and he found that the IFC was still immune. So he only addressed the issue of the location of the gravamen. He didn't address whether this was a commercial activity. He didn't address any of the IFC's other arguments for dismissal of the case. So he found that looking at the case, he felt the gravamen was IFC's monitoring and supervision of the power plant. And he found that we hadn't sufficiently alleged facts in our complaint that showed that gravamen, those acts, occurred in the United States. So he felt they happened in India. And because we didn't meet our burden there, we hadn't shown that the exception applies. He also found that the loan itself was not the gravamen of the case because the plaintiffs hadn't alleged that the loan standing by itself was independently tortious. So what we did after that order is we submitted a motion asking the court to reconsider its decision and amend the complaint to add new factual allegations. So these include clarifying that the loan itself is tortious by itself, and that the monitoring and supervision piece of the IFC's acts happened from its headquarters in Washington, D.C., not in India. And we believe that these new facts can provide Judge Bates with what he felt was missing, and we can meet his test. So the case is still very much open, and we're waiting for a decision from the court there. And whatever the outcome of the immunities decision by Judge Bates is, there will likely be an appeal to the DC Circuit from whichever side loses the issue. And in terms of the impact of the decision, I think Judge Bates's decision really demonstrates that any inquiry into whether a defendant is immune under the FSIA is a very fact-specific determination. It depends on what is alleged, who did what, and where. And so every individual court is going to have to deal with this going forward for other cases if they arise. So it's hard to draw a bright line rule out of Judge Bates's decision. And I think my last point is that I understand that a lot of people are worried about opening the floodgates of lawsuits against development banks after the Supreme Court's decision. And whether that's the case or not, I think ultimately, we hope that communities won't have to resort to lawsuits in the first place, and that instead we hope that the IFC and the World Bank Group in general will take this opportunity to pick better projects, improve their oversight of projects, listen to local communities in order to fulfill their mission of alleviating poverty, instead of just relying on their immunity to protect them from liability and leaving communities without access to justice.
Well, thank you. I think that's a great overview of where the case stands and an actual testament to the fact that this is a live issue and that the law continues to evolve. And let me pick on something that you mentioned at the very end, the question of whether this might open the floodgates for more cases, which was the comment that Justice Brewer mentioned in his dissenting opinion in the decision. And move to you, Nancy, from a perspective and your expertise of national law. How do you see and how do you understand the significance of this district court ruling in conjunction also with that reading of what Justice Breyer mentioned? And in the overall context of the decision in JAM, where it was mentioned that the immunities of international organizations develop in tandem with that of sovereign immunity. So how do you see this evolution? And I would actually include one of the questions that we received already from the audience from Rebecca, asking whether this decision of JAM has changed or pressed IOs to change their accountability mechanisms as a result of JAM. So how do you see that from the domestic perspective in the United States, Nancy?
Thank you. And also thank you, Kenna, because that was really helpful. The way you described the district court case and kind of gives me a little room to discuss the Supreme Court case and a little bit more about kind of what led to the remand to the district court and what the implications of that are. Because I think the district court, as you say, took a narrow approach, and so it doesn't answer a lot of the questions that were raised by the Supreme Court decision. So just to back up a teeny bit, as Pablo mentioned, I'm an attorney at Arnold & Porter, and just so you know, I litigated the Atkinson case, which was in the DC Circuit, decided this issue of the Foreign Sovereign Immunities relationship to the International Organizations Immunities Act differently than the Supreme Court has now decided it. And so we had argued in the Atkinson case that the decision, the way the Supreme Court looked at it in JAM was, we argued against that. But I want to say I'm not speaking for any clients of our firm or for anybody in our firm, just for myself, based on my experience in these cases. And I think it is worth going back to the IOIA and the FSIA's relationship and how that was looked at by the Supreme Court in thinking forward how this commercial activities exception is going to apply in cases. And in particular, just to preface it on Kenna's remarks, because she discussed how the district court looked at this one aspect of applying that commercial exception is the location, looking at the location of the gravamen of the suit. Another step that would have had to have been reached if the court had found that the gravamen of the suit was in the United States was to look at the commercial nature of the activity. And this is what troubled Justice Breyer in his dissent in the Supreme Court in considering the implications of importing FSIA jurisprudence to the international organization's context. And for those of you who haven't deeply read the decision in the Supreme Court, the notion was the reason that they decided that it had been imported was the statement in the IOIA that Congress was declaring that international organizations enjoy the same immunities as foreign sovereigns. And that was back in 1945. Then later in the 1970s, when the FSIA was enacted, foreign sovereign immunities was restricted. And so the question was, do we take that back to international organizations and what is meant by their having the same immunities? So I think this question, although decided in the Supreme Court, is not over because, I mean, maybe that sounds crazy, but I think that what's going to happen is that when cases come up against international organizations and we need to look at the jurisprudence of what is a commercial activity and therefore is what is complained of in the case subject to the commercial activities exception, there's going to be a challenge for courts because the way it's been looked at in foreign sovereign immunities cases is this an action taken that a private actor could take, or is it fundamentally governmental or sovereign in nature? Now, how is a court going to look at that with an international organization that is, by definition, not a sovereign? And what kind of jurisprudence is that going to allow? If you say that, I think if you, well, let me take the case in point, the IFC. So one of the things that troubled Justice Breyer is that some of the FSIA jurisprudence has said that lending, the activity of lending or issuing bonds, is commercial in nature because a private actor could take that action. When you have an organization, an international organization that is established by governments with a fundamental function of engaging in financing to develop less developed countries, to have projects to make it possible for development to occur in those countries, you're faced with an issue of we have embraced immunity for that organization to do precisely what the FSIA jurisprudence has said is commercial in nature. And I think that courts are going to have to think very hard about whether the fact that 20 years before the FSIA was enacted and had a commercial activities exception, Congress was really thinking we should let changes to foreign sovereign immunities for foreign sovereigns eviscerate completely the immunity for these financing organizations that we have embraced, found essential, and in fact codified in the IOIA. So we're going to have to deal with the commercial exception. But what I'm suggesting is that I think courts are going to have to develop something different for international organizations in terms of what is the function that isn't commercial so that you don't go into the commercial exception. What is an international organization function that takes the place of what under the FSIA is the sovereign or government function? That's been explored deeply, but the international organization function hasn't been yet articulated in such a way as to distinguish it, at least for financing organizations, from this commercial thing. So I think that's the task of the jurisprudence going forward. And I think it's critical for lawyers representing the international organizations to delve deep into the history of the organizations and their purpose and the governments that founded them and why they felt that immunities was critical to their functions, to educate courts that we can't just sort of just kind of reflexively grab onto the FSIA jurisprudence about commercial exception and think that it fits here. And I think courts will understand that because it came kind of through this, almost through this sort of backdoor thing with the Supreme Court's decision in JAM, as opposed to Congress actually standing up and saying, here's what an international organization's immunities are now that we understand what foreign sovereign immunities are in this later period. So anyway, that is, I will end there.
No, thank you, Nancy. That's great. And you touch upon one thing that I think now it's the next step that we have to take in this conversation as well, which is now we're going into this question of how do we educate courts and how do we educate international organizations with respect to exceptions. And we've been focusing on the commercial activity exception because that is the onus for GEM. But let me now take the conversation to a 35,000 feet perspective. And I'll add another mix to this from the Mexican perspective when talking about exceptions, which, by the way, Jose, that I see you in the chat, maybe this will address part of your question with respect to labor courts in Latin America. So I'll offer you my Mexican experience to move to this conversation, which is that in Mexico, for example, since 2003, we have jurisprudence from the Mexican Supreme Court that also now limits a little bit more the immunities of international organizations. It recognized that what used to be an absolute immunity, it's no longer such. And the limitation is based on a phrase that is that immunities do not apply when international organizations are acting as any other private entity, which is a little bit broader than just only talking about a commercial activity. But because of that, and here again, Jose, I'm making reference to you because you mentioned labor courts, and this has been the issue in Mexico. This opened the door for cases being brought in the labor relationship between international organizations and, say, for example, non-staff personnel, which courts then determined to be not part of the essential function of the international organization, and therefore fell into this category of other private entity acts. And so we're seeing there other cracks, not only with commercial activities, but now with labor law. And at the end of the day, this is much more linked to human rights in general, as a possibility of having a fracture to understanding that the exemptions for immunities might be broader. So with this overview, I would move on to you, Carla, to tell us more about this. How do you see the evolution of this corpus of law in the 21st century? And in particular, do you see that we're heading to a human rights exception in immunities?
Thank you very much, Pablo. And it's a great pleasure to be here. So thank you very much to Int'l for the invitation. I also appreciated hearing from the previous speakers, including you, Pablo, on the Mexican case. And I hope you can share it with all of us so that we can learn from it. I think it'll be really quite interesting. But on a human rights exception to immunity, it's arisen mainly in cases relating to state immunity. So here we have some of the biggest cases: Germany against Italy at the International Court of Justice, Jones against the United Kingdom before the European Court on Human Rights. So those cases, which have in a way shut down quite a lot of subsequent cases, basically, despite the arguments of some of the parties, and quite strong arguments on the need for a human rights exception, these and some other cases stand for the principle that immunity is not made contingent on the nature of the acts or the absence of a remedy. If the immunity belongs to the offending state, it's not possible, and it's outside the competence of the court to ignore this immunity. So those are the rulings of those courts, which are pretty disheartening in terms of a human rights exception, at least at the level of state immunity. For international organizations, the situation is rather different in that there's much less case law directly on point. I think the closest case, which is of relevance to this, is the Mothers of Srebrenica case before Dutch courts, where the Supreme Court basically cites all of these state immunity cases that I've mentioned, but somehow puts together the question of jurisdiction with immunities, finding somehow on the basis of some kind of an active state or political questions type arguments that because of the political nature of the UN's work to its core existence, this shouldn't be justiciable. So that is the type of argument that was used in the case. And that is then connected directly to immunities. There isn't really a separate consideration of the UN's immunity. It's kind of linked with this active state. But had the court split up the issues on jurisdiction, I think it's fair to say that whether the issue is core to the United Nations or another international organization would depend on the kind of action or conduct at stake. So a suit for failure to act because of a Security Council resolution, one could possibly see that as less justiciable than, for example, if peacekeepers are acting in a negligent way.
We seem to have...
She's frozen.
Yeah.
Or
there we go. There we go. You froze for a bit. Now we can hear you and see you. So continue.
Okay. with respect to immunities, I would suggest that the question is still a little bit open with respect to international organizations, particularly with respect to this if we look at the access to justice case law, which is somehow linked to a human rights exception, the lack of an alternative forum, you have a whole range of cases at the domestic level where courts have decided to allow employment claims from international organization officials because the employee cannot adjudicate elsewhere. And as you've said, Pablo, it's gone even further in some countries, though I think that's quite unique. I don't think it's gone beyond employees in most jurisdictions. But you also have the Kadi case before the Court of Justice of the European Union and other similar cases where, even though they concern claims against states for implementation of Security Council resolutions, the courts had very little difficulty to say that the lack of the remedy was extremely problematic. And those were really important findings, which in both cases, both the employment law cases, but also the cases relating to Security Council sanctions, which led to quite significant changes in internal policy at the level of the UN by setting up stronger employment mechanisms or setting up the sanctions committee process. So I would also just mention, finally, in relation to the floodgates issue, that my sense of the matter is that it's more likely to lead organizations to strengthen internal mechanisms than to lead to a floodgate of cases. So in a way, we'll see that as a positive benefit. But I also think it's important to look at the purpose of immunities and attack the issue from that respect. Because particularly with respect to a human rights exception, one of the main challenges is to consider, well, if there is no human rights exception, then organizations will be immune even if they carry out severe human rights violations. Most international organizations have that human rights protection as a major part of their mandate. That might be even worse for organizations in their future than some restriction on immunities. So to conclude, I would say that there is some, but quite limited, space for human rights exception, given where we are with the jurisprudence. But I would bet far more on an exemption based on the absence of an alternative forum rather than a pure human rights exception. So that's where I think we are in terms of the jurisprudence.
Thank you, and you're absolutely right. The UN Charter, that was our point of departure today in its birthday, requires member states to accord to the UN privileges and immunities that are necessary for the fulfillment of its purpose. And I think part of this conversation, this broader conversation, is how then do we start interpreting what does the fulfillment of its purpose means, and in when you bring it down to specific areas of the law. And with that flow, and we're now the conversation is moving more perhaps a little bit to accountability and what to do with international organizations, especially the UN, because the United Nations, it's very strong on this front. And so I would move to Beatrice now, because you have, Beatrice, firsthand experience litigating against not only international organizations, but in particular the United Nations, on behalf of survivors and victims of human rights violations. And it would be interesting to hear from you whether you think that JAM might be opening the door also for mass tort cases. And especially, I would also weave in the question that Itai sent us, if you also think that this decision of JAM can ultimately impact what she calls as a UN absolute immunity, that is normally the perception that we have when we're talking about the United Nations. So share with us a little bit more of your experience litigating with the UN on the other side.
Sure. Thank you, Pablo. So my experience litigating against the UN is in the context of seeking to hold the UN accountable for the introduction of cholera to Haiti. And as many people may know, cholera was introduced to Haiti by UN peacekeepers in 2010, after the UN deployed peacekeepers from Nepal, where cholera is endemic, without screening them for cholera. The peacekeepers were stationed on a base in rural Haiti that routinely disposed of waste from the base into open air disposal pits that in turn, with heavy rain, would overflow into Haiti's principal river that tens of thousands of people rely on as a primary water source. And so in October of 2010, a devastating cholera outbreak broke out. Over the course of the last 10 years, an estimated 10,000 people have died from cholera, and 1 million people have been infected. And to put that in context in relation to the current COVID-19 pandemic, on a per capita basis, there are more people who have been sickened from cholera in Haiti than there are confirmed COVID-19 cases anywhere in any country in the world at the moment. And so the UN, in the face of staggering evidence showing that it was responsible for the introduction of cholera, denied that responsibility for about 6 years. And so a Haitian human rights law firm called the Bureau des Avocats Internationaux, together with its US partner, the Institute for Justice and Democracy in Haiti, where I worked at the time, ended up pursuing claims and eventually litigation in US court to try to hold the UN accountable and seek remedies for victims. So the UN, as was mentioned, has charter-based immunity, but it also has an additional layer of immunity in treaty, the Convention on Privileges and Immunities of the UN, that gives it an extra layer of protection in addition to the IOIA, and also grants it immunity of a broader scope. And so the UN, as opposed to other international organizations, still retains absolute immunity in US courts, even after JAM versus IFC. In exchange for that immunity, however, the UN does have a treaty-based obligation to hear claims for personal injury, illness, and death, including ones that arise in the context of UN peacekeeping, and to settle those claims out of court through standing claims commissions that are supposed to be established in the host countries where UN peacekeeping operates. So BAI and IGDH initially filed claims pursuant to that obligation, trying to seek the establishment of a claims commission, but those claims were denied by the UN without really providing a well-founded explanation. They said essentially that they do not have an obligation to hear claims that concern some kind of political or policy matter. It has been widely understood that this explanation was not legitimate and was not based actually in any prior jurisprudence or in UN law in general. So against this background, BAI and IGDH brought suit against the UN in federal court in the US. We argued that although we recognize the absolute nature, the absolute scope of UN immunity, and that there are no exceptions to UN immunity, that in this particular case where the UN had breached its reciprocal obligation under the treaty that grants immunity, that the UN could no longer avail itself of immunity in court. We ended up losing that case, but the litigation also played out in the context of a massive out-of-court mobilization, and actually the day before the appeal before the Second Circuit was dismissed, the Secretary General changed course and publicly admitted responsibility, as well as committing to a $400 million plan for remedies. So in some ways, even though there was a loss in court and immunity was upheld, the cholera case is a success story, and that advocacy out of court was able to result in a significant victory. At the same time, though, we see that now it's been 3.5 years since the UN made that announcement and issued a public apology. And to date, the UN has raised only 5% of the money that was promised, and there has not been any compensation paid to victims. So I think what this shows is the limitations of, even in the best case scenario, a response that's approached as charity and not as justice, as grounded in either a recognition of liability or pursuant to a court decision. And so even with these, when you don't have access to an alternative mechanism outside of court that is grounded in legal liability, there are serious limitations to the types of remedies that victims are often able to access, even in this best case scenario when you can mount sufficient pressure. So that, of course, brings us back to the question of whether JAM versus IFC now opens the door to tort liability in situations like the cholera case or other similar situations. I think it's a critical decision in that it draws this important distinction, essentially, as Pablo mentioned, between immunities that protect important functions and also carves out exceptions, including for tortious conduct. But it's still grounded in requiring a nexus to the US. And so, and we've seen that that's been interpreted quite narrowly and likely will mean that the injury still has to occur in the United States. And so in that sense, I think the implications for tortious conduct by international organizations that happens abroad is still likely to be quite limited. And so at the same time, though, I think it's also important to mention that the JAM versus IFC decision, I think, is taking place in the context of a broader trend, both legally and politically. So on the legal level, as Carla mentioned, that increasingly courts, especially in Europe, are recognizing that it's becoming more untenable for international organizations to, on the one hand, claim immunity, but also refuse to provide some kind of alternative mechanism through which victims can seek justice. At the political level, I think that there's also a broader takeaway both from JAM versus IFC and from the cholera case that shows that international organizations, when they're not careful in their operations, can have really devastating impacts on the communities that they're intended to serve. And I think increasingly we are seeing a demand coming out of human rights communities of supporters of international organizations in wanting to see international organizations provide remedies in those cases. And so politically, I think it's also increasingly becoming untenable for IOs to claim sweeping immunities and not do something in response to what are clear injustices. Speaking of the 75th anniversary of the UN Charter, recently Andrew Gilmore, a former Assistant Secretary General, in leaving the UN, called the Haiti cholera debacle the single greatest example of hypocrisy in the UN's 75-year history, and talked a lot about the really detrimental impacts that the lack of accountability is having on the UN itself. And so I think that not only is there a general public growing expectation of accountability from international organizations, but that also it is increasingly becoming in the interest of international organizations themselves to ensure that where there is immunity, there also is some alternative avenue for victims to be able to seek remedies. Thank you.
And no, thank you. And I think this is a very important and central issue that you mentioned, and perhaps it's the heart of this conversation, which is what should international organizations do in this evolution of immunities law and the role and the way in which you put it of how they should not use immunities in the detriment of the people that they should be protecting. And I think that now we would switch our minds a little bit from the perspective of international organizations. You can also see how there is a tense and a genuine dilemma on how not to open or be so flexible with an interpretation of immunities that could lead then to a dismemberment of this corpus of the law, but on the other hand, to allow for effectiveness and accountability to take place. And it's a difficult decision to make, which leads then to the general questioning and the topic that I want to address now with Meke of accountability mechanisms within the organization. Because right now we've been focusing only on how you sue them and how you bring a case or a claim once there's been some wrongdoing, or at least you feel there's been some wrongdoing. But perhaps this could also lead to a revision on behalf of international organizations of their own statutes on the way they operate with immunities. In the case of the UN, we know that the Secretary General still has the power to waive immunities, for example, although that very seldomly happens. But knowing that the reputation of international organizations, the reputation of the UN is at risk as well, depending on how feisty they want to be in many of these scenarios and situations. So Meke, with this background and picking up on Rebecca's question on whether international organizations should change their internal accountability mechanisms, and like taking also the example that Desiree Leclerc has put in her comments of how immediately after following JAM, the IMF, the World Bank, and the IFC announced internal accountability reviews. What could you tell us about how should IOs take accountability and immunities moving forward, and how can international organizations strengthen their own accountability mechanisms for these ends?
Thank you very much, Pablo. Before I delve into the specific question, I think it's pertinent to put everything in context, that I remind people what international organizations are and the purpose of their immunity. International organizations are not the enemy. We are not talking about rogue entities here. We are talking about organizations that were created under international law by member states to foster international cooperation for the purpose of achieving common objectives. The reason why they are given immunities is to ensure that the functions that these member states have invested them with are carried out efficiently, effectively, and economically. So when people are talking about international organizations, it kind of gives the impression that we are talking about rogue entities here that are out to do harm to the communities that they're supposed to serve. Of course, everybody knows that this is not what international organizations do. Of course, mistakes do happen, things do go wrong, but when they do go wrong, the issue is that what is the proper mechanism for addressing something that has gone wrong? Occasionally, we mistake accountability with responsibility. Accountability mechanism actually has nothing to do with the jurisdictional immunity of international organizations. It is a subtle difference. When you're talking about accountability mechanisms, what you're actually talking about are political, administrative, or non-legal mechanisms that you use to hold international organizations answerable for either their omissions or commissions. But when you're talking about responsibility, then you're talking about legal liability for the wrongful conduct of international organizations. The issue then becomes, where do you hold them legally liable for this wrongful misconduct? And the reason for jurisdictional immunity is that the international community, the member states that have invested these international organizations with immunities, remember, the international organizations don't give themselves the immunity. The immunity derives from member states, has decided that in the interest of these member states, you have this jurisdictional immunity so that no member state through its court system will be able to exert undue influence or interfere with the independence of this international organization in order for them to be able to carry out their function. So this is a policy decision that the international community has made with respect to the immunity of international organizations. So when we are talking about accountability mechanism, it's really something totally different from legal responsibility or liability, which is the realm of jurisdictional immunity. But since the question really has to do with accountability mechanism, I will get to that later, but I want to also point out something that people need to understand, since the basis for this panel and our discussion is the JAM case at the US Supreme Court. When we are talking about JAM, it's very important to understand what was decided in JAM and what was not decided in JAM. What was decided in JAM is the scope of immunity of international organizations under the IOIA. So this is a US national legislation that confers immunity to international organizations. The Supreme Court in JAM did not decide the immunity of international organizations under their constituent instrument or charter or the Articles of Agreement of IFC, as the case might be. In fact, what the Supreme Court did decide in JAM was that the IOIA is a default rule when it comes to the immunity of the international organization. And it gives the example that when you come to the United Nations, you have the Convention on the Privileges and Immunities of the UN, which gives the UN the so-called absolute immunity. Same situation with the IMF, but in the case of IFC, under its charter, it doesn't have absolute immunity. And there is a reason for the IFC not having absolute immunity under its charter. It's limited immunity. And just like the World Bank, the purpose of the limited immunity is that when they engage in securities transaction, if they do not make themselves amenable to suit in national courts, then no one will be able to buy their securities or for them even to enter into securities transactions. So there is a purpose for that. And this also leads to your question as to when is it in the interest of an international organization to waive its immunity. I know we use it loosely, waiving and exception, but in essence, what the World Bank and IMF did is that they created an exception under their charter for their immunity, meaning that when they do this securities transaction, then they are not immune from suit. But in other areas, they will be immune from suit. But to get back to the specific question, so when we're really talking about immunity, the scope of immunity has to do with the source of that particular immunity. All that the Supreme Court did in JAM is that if you derive your immunity in the United States under the IOIA, then you no longer have absolute immunity because now the immunity under the IOIA will now be construed in tandem with the restrictive immunity doctrine under the FSIA. But in that regard also, it's equally important to point out that even under the FSIA, we have the so-called treaty exclusion under section 1604 of the FSIA that says that if there is a treaty already in existence before 1976, when the FSIA was enacted, then if that treaty gives that international organization whatever scope of immunity, then that treaty will prevail. So getting back to the accountability issue, of course, like I said, the accountability mechanism is a non-legal mechanism. The World Bank has the inspection panel. The IFC has the compliance and advisory ombudsman. And all these accountability mechanisms are established under what you might call the internal or institutional law of the particular international organization. And of course, the case of JAM has led IFC to review the mechanisms to see where it can be improved. But really, when we're talking about accountability mechanisms and whether they are adequate or efficient, it's usually, do we have an adequate remedy or reparation for the omission or commission of the particular international organization? Sometimes it comes down to monetary issues. Remember, these organizations use taxpayers' monies through their member states to fund international development. The idea is not to pay high-priced lawyers or to engage in litigation and others. But of course, these are very responsible international organizations. And when it comes to accountability mechanism, I think it's more of a governance issue than for the national courts of a particular member state to take it upon themselves or into their hands to not get involved in a governance issue regarding that international organization. So the key thing here is that more compliance with the rules and policies of the organization are called for, because I think overall this makes more sense than having very expensive litigations and payout for non-compliance. So what most organizations are doing is threatening their compliance mechanism. And I'll stop here. I hope I have addressed all the questions that I've raised, but I've lost track of the time because I get very excited when I'm talking about immunity. One last thing, in the interest of full disclosure, I was one of the authors of the amicus brief for the MDBs in support of IFC at JAM. So like Nancy, this is an issue very personal to me. So I'll leave it at that. Thank you, Pablo.
Thank you, Mike. That was great. And it's also very nice and refreshing to hear these passionate explanations of issues. For many of us, international law and these details can be a very passionate issue, despite the fact that I try to convince my friends it is, and they say that I'm crazy. But you're absolutely right, and I want to pick on something that you said, that we shouldn't frame this conversation under the premise that international organizations are the enemy, and that's not what the conversation is about. And being a representative of a member state to the United Nations, we're also very fully aware that there's a symbiotic relationship between the UN and its member states. It's not a separate entity from us. We are the United Nations in a way. And so you're absolutely right and on spot, I think, when part of the question should also be addressed directly to member states in terms of how can we member states raise issues of accountability, use the mechanisms that we have within the organizations that we're parties to make them happen and to strengthen them, because it's at the end of the day, it's always going to be the best solution, not only for IOs, but for member states to find these ways in a constructive manner rather than going through litigation. As you can see, we're running out of time, and I would literally take one last question, which I think is hopefully a simple one and a very straightforward one that Desiree also asked before. And basically, it's if after this freeze that we've had with the COVID pandemic, where pretty much everything is on hold, will JAM regain momentum as it was doing up until we paused the world? So we heard from Kenna that there's still ongoing things. So I guess the answer would be yes. But I would very quickly go perhaps to you, Kenna and Nancy, to get your views on whether you think JAM will gain momentum in the 4 minutes that we have left. Thank you.
Yeah, thank you. I mean, a decision could come out any day from Judge Bates at the moment. So things are moving forward. And we're excited to see what the district court comes out with. I just wanted to, in addition to this, flag two things that were said earlier. I think we all, on the issue of accountability mechanisms, we all recognize their importance. But I do want to flag what happened here in JAM. The communities here did go through many years of working with the CAO in terms of pursuing those processes. And the CAO did find that the IFC had violated its policies here. And the response from the IFC was to do nothing, because the CAO here cannot force the IFC to pay reparations or do anything like that. So that's really the importance here of having an alternative remedy in terms of litigation. Obviously, we would prefer not to, go through this. It's been 5 years since the complaint was filed, and the communities still have not, seen justice. We're still at the beginning of this lawsuit. So I just wanted to note that in terms of accountability. And in terms of waiver, both the IFC and the World Bank have broad waiver provisions already in there. I know that probably Nancy and Mecca won't agree with me, but if you read their articles of agreement, there already are broad waiver provisions already in there, and courts have recognized that. The only real exception to a waiver for their immunity is from member states. They don't want to be sued by their own member states, but otherwise it is a broad categorical waiver. And I think we should trust the architects of those articles of agreement and recognize that they didn't think that immunity was necessary to do their job.
Thank you. And Nancy, so in the final minutes that we have and closing the circle, going back to the developments here in the United States, will JAM regain momentum? What's your view on this?
I guess the question there is whether we mean JAM itself and its movement through the courts. And I think Ken has addressed that, and that's just a matter of how quickly the courts act and then what the next steps are. It's conceivably could go back to the Supreme Court on another point of law. As to its impact, I think that also depends on facts of other cases, raising of other cases, whether plaintiffs come forward in other litigations to see how the jurisprudence develops. So, I mean, doubtless it will have impact. How quickly we will see that just depends on factual issues.
Thank you. With the final minutes that we have, then I would use them to go back to you, Beatrice. From your point of view, how do you think it's moving forward? Like in the sense that IOs would stop agreeing to arbitrations to avoid the exceptions, or on the contrary, we'll see a different development?
Yeah, I think that's the hope, right? And certainly something that we will keep fighting for. I think we are finding ourselves in a very long arc that does bend towards justice, and I think that there will be a healthy balance found there.
Well, this has been great. It was a very rich conversation, I think. I have to say that I'm also delighted of the fact that this was a panel of women empowerment, and this is great. And we're run out of time. So thank you very much for being here, for sharing all your views and your expertise, and for all of you out there who logged in to watch this panel. We hope it was interesting and useful, and thank you very much for joining us this afternoon. Hope to see you soon in person. Have a good afternoon.
Thank you.
Thank you, Pablo, and thanks everyone, and nice meeting virtually.
Yep.
Thank you all. Thank you.
Thank you, ASL.